Hi, my name is Scott Green. I am the managing partner for the Green Law Group in Simi Valley, California. Today's webinar is all about how to secure and collect what you earn. This is for contractors, California licensed contractors. And this is the second part in our series. Today's focus is going to start with preliminary notices and include mechanics liens, releases, stop payment notices, bond claims, and a few other tidbits. Before we get into the meat and potatoes, I'd like to thank our sponsors. I think we've got a slide with, there we go. So at the top of the list is Easy Law construction notices. Full disclosure, that's my company. I formed Easy Law in 1985 when I was in the construction business. By the way, I graduated law school in 1978, and for the first 10 years worked with my father in construction, doing pretty much everything in construction, including being in-house legal. And along the way, I had to learn how to secure our payment claims. And so in that process, I learned that a lot of subcontractors in particular would get left out when, let's say, their client went bankrupt or their client was insolvent for one reason or another. And if their particular contracting client was the only source of financial recovery, they'd be left out. So I started Easy Law construction notices back in 1995 or 85, excuse me, to help contractors secure other opportunities to collect their money. And we'll talk about that as we go forward. But if you haven't checked out Easy Law, please check them out on the web, and I recommend them highly. The Blue Book. The Blue Book has been around forever. Those guys are great. Bill Gribble at the Blue Book is wonderful in terms of helping contractors market their services and develop networks. Highly recommend them. The Builder's Book in Canoga Park. Usa Awad is the owner of the Builder's Book. He's been around, almost as long as I have. And if it's in writing and if it involves construction, you can find it at the Builder's Book. And they have a great website. If you don't know them, check them out. The Ventura County Credit Union, why are they on there? They're on there because they're fantastic working with contractors. They're my lenders. And just like contractors had all kinds of problems in the financial crash 2008 to roughly 2012, when it was hard to get a bank to pay any attention to you, Ventura County Credit Union looked at more than just the numbers. They're great folks there, and Sean McCullough in particular. He's somebody, if you're looking for interested in a new lender, give Sean a call. And then the Ventura County Contractors Association. If you're in Ventura County and you're a subcontractor, you ought to be a member, because you can network, have some fun, meet some other people in the business, be able to make referrals, have referrals for yourself. And they have a plan room and different things like that. Good group of people. Plus, they go golfing once or twice a year and go fishing. So have a good time with them as well. So thank you to our sponsors. So moving on, see if I can get this right. Okay. We're using what I call a PowerPoint, which is a 200-page plus creation that is something I've been working on for years and years and years. I add to it when new cases come out. It's all about legal issues for contractors. And so I start off here just letting everybody know, look, the more you know, the better. So I recommend, this information, the whole thing to our listeners. And I have to give you this fair warning. My comments are general today. They're not specific as to your particular legal matter. For specific legal advice, the facts are going to be critical. So you want to not just rely upon the general information you get from me. Talk to me or somebody else who's an experienced construction law attorney, and because your particular facts may change what the impression that you get from what I say today. All right, it's a little bit about my law firm. You can read that later if you're interested. This firm is built for contractors. I think that's pretty much all you need to know. And it's not just me, it's a bunch of good first-class attorneys. My partner, by the way, is also a licensed general contractor. So, preliminary notices. What are they all about? Why are they important? When do you do them? How do you do them? So let's chat about that for a second. And you can go back and read through this information later. But the big picture on preliminary notices, you want to do them at the outset of all of your projects. What do I mean by that? When you sign a contract, send a preliminary notice. Just make that your standard operating procedure. Otherwise, if you decide, well, I'm going to wait till later and see if I have any payment problems, or, we'll get to that, it gets forgotten because even if you're using a service like my Easy Law service, doing the preliminary notice is not, top of mind generally. I want you to make it top of mind, particularly in this COVID environment where, construction lenders might pull the plug on a project for reasons that have nothing to do with the actual construction, but more to do with the financial solvency of the property owner. And if you haven't done a preliminary notice, that could end up, leaving you out in the cold. I'll give you just a little war story about a conversation I was having with a couple of our attorneys this morning, where we have a client who does large projects, significant dollar projects, and had projects that were well underway, working for the projects are owned by LLCs, and there are construction lenders on these projects. There's some common ownership between a couple of them. The lender, for reasons I don't quite yet understand yet, pulled the loans. And so our client, who is in the prime contractor, general contractor, has substantial obligations outstanding to subcontractors, very substantial obligations. So with the lender having pulled the loan before the projects were completed, there's an amount of money that's still in that construction loan. And there's a way to access that even when the lender forecloses. But that access depends upon or starts with serving a preliminary notice. And what general contractors don't often understand is that they also must do preliminary notices when there is a construction lender on their projects. So when there's a construction lender, the GC's got to give a preliminary notice to the lender. If you don't, and then the lender forecloses on the property, you can't access those construction funds with a stop payment notice, I'll explain more about that later. Or with a mechanics lien. You might have a lien recorded against the property, but generally speaking, a construction lender's foreclosure is going to wipe out mechanics liens because the lender's loan will have been recorded before any construction work started. And in the foreclosure law, the party with priority being the earliest one to encumber the property or record a loan against the property or lien, the earliest one has priority over claims that come later, which are referred to as junior claims. So with a lender foreclosing, they can wipe out your mechanics lien. But if you've got a preliminary notice that went to the lender, you can do a stop payment notice. And a stop payment notice attaches to undispersed funds in the construction loan account. Now, you might have to bond that notice. In fact, you do when you submit a stop payment notice to a construction lender on a private project. You have to bond it, which is an important step, and that's going to cost you a little bit of money. But if you can do that and assert a good claim against the lender, then the lender's foreclosure on the loan may not hurt you because the lender will be forced to pay you. Now, you might have to take them to court to make that happen, but if there's enough money at risk, then you got to do it. So that's just one instance where a preliminary notice may not be something that a general contractor may think applies to them, but it does. For subcontractors, you always, and suppliers, you want to do a preliminary notice whenever you're not contracting directly with the property owner and there's no lender. If you have a direct contract with the owner and there's no lender, you don't need a preliminary notice. However, doing it is never going to hurt you. And particularly if you use a service to send out the preliminary notice, it gives a not too subtle message to the property owner that you intend to be paid for your work. So I don't see a downside in serving a preliminary notice, even when it isn't strictly required. I do see a downside with folks who didn't think they needed one, so they didn't, or they don't have a standard procedure of sending them out at the outset when they sign a contract. And then they get in touch with me and say, geez, I'm owed a whole bunch of money. And I want to know, well, I want to take a look at your contract. And by the way, did you do a preliminary notice? And far too often, the answer comes back that they did not do a preliminary notice. And so what that means when you don't do a preliminary notice is your only opportunity to collect is from the party you contracted with. And if the party you contracted with isn't getting paid, or misbid the project, is insolvent, goes bankrupt, you're going to be out of luck because in the construction business, you're really in the unsecured credit business. Now, that might sound wrong. It might not. You might think, what do you mean unsecured credit? Well, think about it for a second. Do you get paid up front? No. I mean, with limited exceptions, you might get a little money. If you're doing home improvement contracting, for instance, the law allows you to get $1,000 or 10% of the contract amount, whichever is less. But that's, a pittance generally. And there is prohibition with the contractor state license laws preventing contractors from front-loading projects. So, you're doing a $300,000 remodel. You can't say, I need $100,000 down to cover my, initial expenses. Can't do that. So what do? You bill for as progress of the construction is made. So you submit progressive progress payments after you perform the work. Well, that means you're, granting credit to your customer for those amounts, which can be very significant. So since you're in the unsecured credit business, anything you might do that will allow you to secure the right to payment, you need to take a hard look at, and you need to do it. And that first step to securing your right to payment, preliminary notice. So you can take a look at the rest of the screen at your leisure. Let's move on. Here's some more information about, well, who does that preliminary notice need to go to? It needs to go to the owner, general contractor if you're a sub or supplier, and the construction lender. And it's got to be accurate. So if you have the owner's name wrong, that's not good. If you have the address wrong, well, that's not good. If you don't send these out certified mail, well, that's not good. There are a number of requirements to get these things strictly accurate, because when done correctly, they're powerful. They give you the right to follow up and secure your payment with, for instance, a mechanics lien. And let's just bump over to that because we want to move this along. And you guys can go back and read this stuff a little later. Now we're on mechanics liens. So very powerful when you're not being paid. Mechanics lien is a temporary encumbrance against real property. What does that mean? It's just like you lent money to this property owner, and you got to record a document against the real estate that says you're owed money. That's what a lien is. And so the mechanics lien, the amount is the unpaid amount of your contract, or the statute says the reasonable value of your work, whichever is less. Why is that comment important? Let's say that you completely misbid a project and you're underwater on your bid. The contract is breached, not by you, but by the party that hired you. Legally speaking, you may have an opportunity to argue for the higher of reasonable value or your contract amount in a breach of contract action. But with a mechanics lien, it's always the lower amount. So it generally means your lien amount is what's due under the contract. That can include change orders that weren't fully executed. As a for instance, you may have an argument for delay damages, let's say, but if you get into a heavy delay damage situation, you want to talk to a lawyer first, because if you overstate the amount in your lien, let's say you think you're being clever and you're owed 100, and you think, well, I want to put as much pressure on the owner as I can, so I'm going to lien that property for 200. Well, that can make your lien void because you intentionally overstate the amount due. That can void out your lien. So you don't want to do that. So it's something you need to pay close attention to and understand. And if there's enough money at issue, talk to your lawyer about it, and particularly make sure your lawyer understands construction law issues. So when can you do a lien? And I'm losing my voice already. My problem is I talk too much, and if you don't believe me, talk to my wife. So when can you record a lien? Your time to record a lien is generally speaking within 90 days of completion of the entire project. And now that's not just your work, that's the entire project. What defines the entire project? That would be the owner prime agreement. So if, let's say you're a plumber and you're working on one of these mega mansions, and you get all the finished plumbing done, on January 15th, does the 90-day clock start ticking for you on January 15th? No, it doesn't start to click until the entire project is done what would be evidence of completion of the entire project? It's a factual question. Evidence would be a certificate of occupancy, final inspection, the property being occupied. So a lot of times folks think, oh my God, I haven't been on the project for months. Can I still record a lien? Well, if that project's not done or hasn't been done for more than 90 days, the answer is generally going to be yes. But this also means you don't want to dilly-dally. If you are on a project and you're not being paid, and they're 60 days into you, and it's a good chunk of money, you want to consider, whether or not a mechanics lien might be a good option at this point. Because when you record a lien, your work either has to have been done, or there needs to be a breach in your agreement for payment. So if you're not being paid in accordance with the terms of your contract, you may have the right to record a lien. Once you record a lien, it's only good for 90 days. It's a temporary encumbrance. What does that mean? It means that if you don't take legal action to enforce your lien with a foreclosure action, within 90 days of the day the lien was recorded, that lien automatically becomes null, void, unenforceable. So when you record a lien, what I suggest is that you consider that you've got 60 days to try to get a settlement worked out. If you don't get something worked out in 60 days, then day 61, talk to your lawyer. And that gives your lawyer enough time to write a letter to the property owner and anybody else that owes you the money. And the lawyer can say, look, you owe X. There's no justification for not paying. Here's the legal action we're going to take unless this matter gets resolved like by day 75. And you've got the ability to put some pressure on the parties that owe you money. My office backs up to a train, so every once in a while you'll hear a train go by. So timing and understanding the timing is important. With the PowerPoint, which I think we had the full PowerPoint attached to the first webinar, you can look for the claimant's time chart. I think we might have it in today's webinar as well, and see what your deadline dates are, because you need to think forward and plan for potential legal action, because these things have short statutes of limitations. So here's more written information about what we were just speaking about. Here is information about what has to be in the mechanics lien notice. A lot of folks, will record their own liens and try to save some money, and then blow it and not do that correctly, or give it to the right parties, or record it against the right property. If you're owed a decent chunk of money, don't try to do this on your own. Use a service like mine or somebody else's. But I could potentially rewire my house, but more likely I'd burn the thing down, because it's not what I do. So unless doing liens and such is something you do on a regular basis, get somebody who specializes in that. Because you have to also have a proof of service, which is the page we're looking at now, proving that you sent it to all the correct people and in the correct time frame. So failure is going to invalidate your lien. Design professionals. There might be a sprinkling of design professionals out there. Architects, for instance, you're a design professional. You've got some special rules. If you're one of those, you have a question, shoot me an email. Okay, stop notices. This is what we touched on a little bit earlier. It's got to be bonded. It doesn't necessarily stop the project. A lot of people think that a stop payment notice shuts down the job. It doesn't, although if there are enough of them, a lender might pull the plug. But what it does do is it is a claim against undispersed money in a construction account. So read this, powerful, it's a powerful remedy. And like I said, in the event the lender forecloses, your money could still be secured with a stop payment notice. Bond claims. On private projects, bonds are fairly rare, more likely on public works, and we'll get to that later. I don't know if that's today or another seminar, but a payment bond, real briefly, is posted for the benefit of potential lien claimants and is another avenue for recovery, and is also something that requires, in most cases, a preliminary notice. So that first step, the preliminary notice step, don't miss that. Do it every time. Here's some drill down information about payment bond claims. Read that at your leisure. All right, public projects. So the rules are different on public projects. There is no mechanics lien on a public project. You can't lien the school and then sell it to get your money, right? So in exchange for the fact that you don't have a lien right on public projects, the direct contractor prime has to record has to obtain a payment bond. And the payment bond is a substitute for the lien right. And so when you're not paid on a public works project, it's a great remedy. You want to make a payment bond claim. And if you have to go forward against it and you prevail, you get attorney's fees. So it's a powerful claim. And read up about that. Some more info on that. Now, on public works projects, if you bid directly to the prime, you don't need a preliminary notice. But I hate to tell people that because that kind of encourages people to take discretionary action and not always do a preliminary notice. My concern is that people make bad decisions when they don't just have this standard operating procedure, sign a contract, do a prelim. If you start throwing some discretion in there and thinking, oh, gee, do I need to do it on this one because I think I'm going to get paid, or I think this is a public works project, you're going to, more likely to end up in a position where you inadvertently lost your rights. So my view is use the keep it simple, stupid rule. Sign a contract, do a prelim without fail. Federal projects, they're different. There are no lien rights. There are no stop payment rights. There is something called a Miller Act bond. And your notice on the Miller Act bond comes at the end of your work on the project. So within 90 days of the last work on the project, you have to assert a Miller Act claim. Powerful remedy, but federal jobs are different. If you're on a federal project and you're not paid, talk to your lawyer. All right, let's jump through. There's information here on prevailing wages. You want to read this. I'm trying to cover a lot of information in a short period of time. And so I'm encouraging you to read these slides and then follow up and shoot me an email if you have a question. Here's some info about retention amounts on public projects, which are generally good news for subcontractors. Completion dates, information about that for public works is important to understand. This is a case dealing with the failure to pay prevailing wages. If you're on a public works project and you don't understand what prevailing wage requirements are, stop, learn before you go take another step, because if you don't get this right, it's bad news. Okay, now we're getting into releases. Conditional progress, unconditional progress, conditional final, unconditional final. If you've been in this business for any length of time, you're using releases. You understand what these releases are. The key is read the darn things before you send them off. For instance, you may be asked by somebody to give an unconditional final release before you've been paid. Well, if you read the document, it says in big bold letters that you shouldn't do that. If you have not been paid, do not give an unconditional final release, because that waives all of your lien rights and your bond rights and your stop notice rights. Sometimes folks will say, hey, I need the unconditional so I can pass it up the chain and get paid, and they'll put pressure on you to do it. You want to respond by saying, no, that's what the conditional releases are. So pre-payment, you use a conditional release. Post-payment, you can give somebody an unconditional. Very important to understand. This next slide is about using the correct through date on your releases. Read this info, read this case example. I think it's pretty self-explanatory. If not, follow up with me. Now I got a nice little chart here. Actually, it's probably pretty confusing. You need to take a few minutes and follow the flow. But whoever is doing payments and releases in your office should spend time on this chart to understand it. And then if it's still confusing, talk to me. Here are samples of the conditional and conditional releases. Here's a pitch for Easy Law. And by the way, Easy Law has all the releases on their website, and the program is designed to populate those releases, make it easier for you to use them when you've done a preliminary notice. So here is that claimant's time chart I talked about earlier. This is giving you, and this is a critical tool. This is telling you when you need to take action, with a couple of a note on best practices. Go through this, read it at least once. Make sure the folks doing payment follow-up in your office understand it. Here are the timelines for mechanics liens, and it varies if you're a general contractor or a subcontractor or a supplier. Here's when you have to take legal action to enforce it. Something called the lis pendens. That comes after filing a lawsuit. Your lawyer will handle that. Here it is for payment bond claims. So this chart took me a while to put together, but I think it's very, very useful for our clients to have handy, because if you go past the critical date, well, you may not be able to recover from that. So you need to understand what these dates are and calendar them internally, so that you contact your lawyer with enough time to take action. You contact Easy Law or whatever notice service you're using with enough time to take action. You don't want to wait to the last minute, because all these things have lead time. If you call me up on Monday and say, hey, Scott, my rights are running out on Tuesday, I'm going to say, man, that's too bad, because I'm busy. And even if I wasn't busy, probably can't do it. Because when you contact a lawyer, first thing I'm going to say is, I got to see your documentation. I got to see your contract. I got to see your prelim. I got to see you got proof of delivery of service of these things. I got to see if they were done on time. I got to see if they went to the right people. There's some work that we've got to do before we can get a lawsuit down to the courthouse and file. So do not wait till the last minute. All right, small claims court. Hey, if you're owed, $2,500, maybe up to $10,000, depending on what the claimants, who the parties are, or maybe only a max of 5,000. Small claims may be a good spot for you, because there are no lawyers, and you won't incur attorney's fees. Okay, I think we got through, and we're pretty much running on time. I know I blasted through a lot of information here, and some of this is going to take some time to digest. So you see my email down there. If you've got questions, or if by the time you look at this, it's like a couple of years old, and you want to make sure that the law hasn't changed, shoot me an email. I prefer an email over a phone call. Emails are a lot more convenient just to respond to. Oh, and this has got the staff email on it. You can just, to get me, it's Scott at thegreenlawgroup.com. And when you do email me, often I'll respond with an answer, and I'll maybe attach some written material that might be helpful as well. So that's our webinar for today. And next up, let's see, we're going to be talking about construction contracts, terms and conditions of contracts, breach of contract claims, home improvement contracts. That's very important to understand that. Pool contracts, a lot of good stuff. And then we're going to end a little bit on bankruptcy law and how it affects folks in the construction industry when you're on a project and your client goes bankrupt, or hopefully not, you've got to make use of the bankruptcy laws. So that's it for today. I have fun doing this. I hope there's some information in here that is helpful to you. Our goal is to help our clients avoid legal pitfalls. We believe it or not, we don't want to see you have to go to court. We live in the courts. We have plenty of litigation work that keeps us busy, despite the fact that we work very hard to try to educate our clients so that they don't have to end up in litigation, which is generally the last place you want to be. It's pretty much always good for me. That's how I pay the bills, but may not be for you. And I'm talking against my own best interest here, but that's just the truth. You get involved in a big chunk of litigation, and let's say you're owed a couple $100,000, you might have to spend a couple $100,000, and then there's no guarantee in court that you're going to win. You're not going to get a guarantee from me or any other ethical lawyer. There's always a risk involved, no matter how good the case looks. So you want to educate yourself. You want to be very proactive about resolving disputes. Earlier is always better. Sometimes you just need to take a haircut, recognize the realities. If you've got folks on the other end that are in financial trouble or are just going to beat you up financially, dragging you through the legal system, sometimes you just need to cut bait and move on. And that's just the reality. We pride ourselves on helping our clients make good business decisions regarding their legal affairs. So we're not going to lean into your emotional angst and try to push you into litigating when that's not in your best interest. And if we do, end up recommending litigation, we'll talk about return on investment, what makes sense financially, chat about budgets. But the thing to understand about litigation is it's a moving target, and we cannot see from the beginning all the way to the end. We have to kind of break it down into bite-sized pieces and tell you what it looks like initially. And then as we get more information, adjust those, our assessments based upon what we learn. It's also something where we encourage our clients to be very proactive, because when we have a proactive, engaged client, it makes us better lawyers. So anyway, I hope you're doing great. I hope this was informal, and shoot me an email if you have a question, and we'll see you next time. Thank you.